It's my pleasure this morning to shine a light on privacy matters in our region. And to do all of this, I am joined by two esteemed colleagues whom I'm privileged to introduce to you this morning. To my left, Ms. Titi Ling, who is Assistant Commissioner for the Personal Data Protection Commission in Singapore, and Mr. Junichi Ishii from the Personal Information Protection Commission of Japan. Prior to joining the PDPC, Ms. Lee conducted criminal prosecutions focusing on financial and technology crimes in the State Courts and High Court of Singapore. She has also served as the Deputy Senior State Counsel with the International Affairs Division, Attorney General's Chambers of Singapore, where she represented the Singapore government at international negotiations and advised Singapore government on public international law, in particular, trade law, intellectual law, and media and technology law. Our second panelist, Mr. Ishii, who very much, I know, wanted to be with us here in person, but COVID had other ideas apparently about that, and so I know that Junichi is recovering, but he's going to join us by video. He is joining us by video. He is the Director for International Affairs at the Personal Information Protection Commission for Japan. He also serves as the Chair of Data Privacy Subgroup for the Digital Economy Steering Group in APPA. Prior to joining the PPC in 2018, he was seconded to the PPC from Yahoo Japan, where he had worked for 13 years. So I am going to see if we can get this working. Am I pointing this? There we go. So just in terms of what we're going to quickly do here this morning, is that three of us are basically going to take you on a tour of those matters that make the Asia Pacific region so important on a global stage. We're also going to provide you with an overview of the Asia Pacific privacy authorities, which brings together regulators from the region, and then spotlight three of those jurisdictions, Singapore, Japan, and my own country of Canada, briefly, and talk about data sharing mechanisms for businesses and regulators in the region. And at the end, I hopefully will have a few moments for questions. So as long as I've been at work for privacy regulation, a good deal of the focus, and really for good reason, has been on Europe, UK, GDPR, and the various iterations of mechanisms for data sharing transfers between Europe and the US in particular. Again, all for, I think, for very good reasons. But meanwhile, other factors, not the least of which are economic and political, have tilted the world's axis towards the Asia-Pacific region. A good deal of the world's population is situated around the Asia-Pacific rim, and population is growing, of course, quickly, including the economies of the region. And just a few of the facts that we would have you to consider. Wealth grew fourfold in the Asia-Pacific in the last 20 years, and the region now accounts for 42%, or over $200 trillion worth of total global wealth. Asia was the destination for one out of every $2 in new investment over the past decade, and 43% of the world's top 5,000 firms by revenue now have their headquarters in the region. My own home province of British Columbia, which, as I mentioned, is Canada's gateway to Asia, sends almost half of its exports to the Asia-Pacific. So what of data protection frameworks in the region? First, unlike Europe, we do not have a common regulatory scheme. The countries of the Asia-Pacific have grown their own unique privacy laws and processes which reflect the broad, I think, and diverse nature of the region. Nonetheless, those laws are often derived from the same basic principles, and they have been both informed and informed by legislative developments elsewhere, including the GDPR. As the economies of the Asia-Pacific sustained growth in the 1990s, privacy law began to take hold, and so did a strong desire amongst regulators in the region to work together. The Asia-Pacific Privacy Authorities, or APPA as it is known, can be traced its beginnings to what were called the National Privacy Agencies Conference held in Australia in the early 1990s. The NPA started with New Zealand and Australia and a handful of others, and gradually added members until 2006, when it was adopted the name APPA, the Asia Pacific Privacy Authorities. From those early meetings, APPA broadened its geographic sphere of influence across the Pacific, initiating joint projects such as the annual Privacy Awareness Week and twice annual forums, We've added working groups, the technology working group, communications working group, and a statistics group that really looks to define baselines for commonalities in the region, including, for example, we recently did work on reasonable security standards set by each of the entities, jurisdictions across the organization. Today, we have 19 members across 12 countries. My own office in Victoria, British Columbia serves as APPA Secretariat, and I chair the governance committee of APPA. Last meeting actually was hosted by our office, the 56th meeting of APPA, and besides APPA members, those who attend include regulator colleagues across the globe, observers from industry, government, academia, and civil society. What we discussed, and I think this is typical of the meetings we've held over time, are common privacy issues and enforcement challenges, sharing knowledge, really all aimed with a view to enhancing cooperation. The last meeting looked at 4 key themes: enabling cross-border data flows, guidance and enforcement, virtual healthcare, and of course matters related to COVID, which were on all regulators and jurisdictions' mind. Before turning to my colleagues, I do want to briefly mention that at long last, privacy reform seems to be moving forward in Canada at a federal level. A privacy law proposing new legislation has just been introduced in our Parliament. If passed, it would replace the existing law, which is more than 20 years old. The Digital Charter Implementation Act actually contains 3 statutes. Some of you may have heard of our old law, PPA. That would be repealed, replaced with the Consumer Privacy Protection Act. The CPPA reflects GDPR actually in many ways, including matters such as data portability. It is still by and large a consent-based statute, but it actually will import the notion of legitimate consent. Obviously, the Canadian government is concerned about wanting to maintain its adequacy status in the eyes of the European Commission. The second act creates an administrative tribunal to deal with matters such as administrative monetary penalties, those being issued against companies. And the third statute, which may be of interest, is the Artificial Intelligence and Data Act, which purports to tightly regulate what is called high-impact AI and to ensure that the AI being implemented does no harm. We're going to be watching things obviously very closely. You should probably be watching carefully in privacy laws and business, because I expect there'll be an update in Stewart's publication in short order.